Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our every other alternate Thursday community conference call, which we've been doing for several decades. Now, before I get started, let me just make sure that you guys can hear me okay. So,
The conference is now in conversation mode.
Am I clearly audible, folks?
Yes.
Okay, excellent. Thank you.
Yes, Rajiv, I can hear you.
Thank you. Okay.
The conference is now in presentation mode.
Okay, so I have marked some questions as frequently asked questions. I'll go over those first. And all the disclaimers that you heard when you were logging into the conference apply. With that, let's begin with the first frequently asked question. This one is about I-140 employment authorization in compelling circumstances. So what exactly is this? What happens is, a couple of years ago, maybe 3 or 4 years ago, the USCIS gave us regulations, maybe it's more than 4 years, before Trump's time. The USCIS gave us a regulation that said if your I-140 is approved, but your dates are not current, and something happens that you have this compelling circumstance where we feel that it's appropriate to issue you employment authorization, we'll do it. It was very useful for some people, this idea of compelling circumstances EAD. Very useful. It still exists. This provision still exists. It is unattractive for certain reasons that I'll explain in a couple of seconds. But we have used it many times and it worked out. I'll give you an example. We had a doctor who had very serious spinal problems and he couldn't know when he would get tired and when he would have to not report for work. So an H-1B is not appropriate when you have these weird hours. It's probably better to get a compelling circumstances EAD. That's one example. Another example was a guy who was an SAP guy. He lived in this particular community, very small community, and the company that employed him closed down. Now in his own area, it was pretty much impossible to get an SAP job because all other businesses were not of that size. They didn't use SAP. So he needed to look for another job and he had bought a house. His kids went to school there. So it was very difficult for him to move out. So this was kind of a compelling reason for us to get him a compelling circumstances EAD. For those of you who are still logging in, compelling circumstances EAD is still available and it can be given where I-140 is approved and the dates are not yet current, but something happens that you should be getting an EAD instead of an H-1B. The reason I don't like it, unless it is necessary, is this. First of all, if I recall, it is only given on 1 yearly basis. Now, the interesting thing is your spouse is also eligible. So you and your spouse can both get compelling circumstances EAD. But you are not any longer on H-1B, H-4. So therefore, if you want to file a 485, I believe you'll have to go outside, get a visa stamp and come back in like an H-1B, H-4. And if you forever, you can keep getting extensions, but if for some reason the compelling nature of your situation changes, you can no longer get an extension. Again, you are stuck with having to go outside USA, get a visa stamp and come back. With that said, let us look at Snehshri's question, which is marked as question number 2 in today's call. So for Snehshri, what has happened is lost job, and through these calls and our discussions found a new H1 eventually in the grace period that was applied. So now the compelling circumstances EAD biometrics has arrived. Should I go for biometrics to get this EAD? Absolutely not. If it is not needed, I don't think you should. So no, I don't like it because if you wanted to convert it to something more usable that needs a status, for example, filing a 485, it's a lot more difficult. You have to get an H-1B again. So I feel that in EAD compelling circumstances, EAD should not be used. And if one of the reasons for your compelling nature was loss of job, that is no longer true because you've got a job. Okay. So I would, if I were you, I would call the USCIS. I would ask them that I want to withdraw my pending compelling circumstances EAD, and I would then send them also a follow-up mail. Everything should be in writing. Don't ever rely upon just a conversation. So in my opinion, sir, you should withdraw your, or Miss Ma'am, I don't know, Snehshri, ma'am, withdraw your compelling circumstances EAD. I think it's both inappropriate and useless for you as far as I can tell. If anybody has a follow-up question on this, press *5. Please don't ask any new questions, any follow-up questions. Okay. Let's go on to the next one. This is a frequently asked question about criminal charges in immigration. I combined two different questions because they both were kind of in the same area. So I cannot give you exact attributes or exact problems that could be encountered in criminal charges, but I can make a few fundamental points clear to you. First of all, if you are never convicted, what is a conviction? When judge says you're guilty. That's the normal understanding, but I'll explain it further. If you are never convicted, no matter what the charges were, even if you were charged with, heaven forbid, murder, but the charges were either dropped or you were acquitted, the judge said not guilty or the jury said not guilty, there are zero consequences in immigration law, because an acquittal is an acquittal. The problem is the definition of conviction under immigration law is different than the definition of conviction in immigration law, or immigration law and criminal law are different. So what is the difference? In criminal law, there are some very specific things that have to happen in order for a conviction to be complete. For example, a judge or a jury has to say that you are guilty. In immigration law, not so. Sometimes you can admit your guilt by implication rather than a specific finding by the court. For example, sometimes you can do a plea deal. Okay, so if you do a plea deal and as a part of the plea deal, you have to admit that you did it, even though the charges are dropped or the judge never found against you, you could still be considered convicted under immigration law. So number one, if you are acquitted, you have no consequence. Make sure whatever deals you are making are reviewed by a local immigration lawyer who does deportation cases. Very important. And third point to remember, the rules for being deported, what is called removal, and the rules for being admitted, such as applying for 485, these rules can be slightly different. What is not a problem for one could become a problem in the other. Okay, so these are the 3 or 4 principles. Then there is something called petty offense exception. Certain crimes are ignored because they are too small to be thought of as a big deal. Certain crimes that are not crimes of moral turpitude, which means they did not involve some dishonesty or something more than just a simple crime. For example, many times a simple assault is just a misdemeanor, which means a small crime, whereas assault with a deadly weapon becomes a felony, which is punishable by more than a year in prison. So there are all these various complications, very difficult for me to make a rule for it. Every case is different. Every case should be evaluated carefully. With that background, there was a domestic violence charge that got dismissed in pretrial. Now, and you had to take 4 to 5 anger management classes. But this was not required by the court. Very good. because that means you probably did not agree to any, or you did not have to convince the court or confess to your crime anywhere, even by implication. But I would anyway like your case to be assessed by a local immigration lawyer who does deportation cases. They usually know this area of the law fairly well. And when I say local, local where you were charged with the crime. I could study Pennsylvania law, but I would still need a Pennsylvania lawyer to bless my conclusions, because I'm not admitted to practice law in Pennsylvania. So we can provide limited help. I think it is important to talk to a local lawyer. Okay? Most criminal defense counsel are actually working these days with immigration lawyers as well locally. So when there is lack of evidence and there's no finding of guilt, I don't think it's a problem. But please double check. You don't want to treat this casually. Okay? Can I be deported when you apply for 485? I doubt that very much from what you have said, but I would not want to give you a definitive voice on this simply because I don't know your case and the exact details of the law. From what you've told me, it doesn't look like you have a problem, but I don't want you to take my word for it. I think so. The 485 looks pretty good, but I think you should talk to an immigration lawyer. I don't think you need to worry about this, but it is a good idea to get the final stamp of approval from somebody who is an expert in the application of the local criminal laws to immigration law. Okay? And the second question from Ash was, there was some argument and physical altercation. They were arrested. Does arrest become a problem for visa stamping? No, it can cause some delays. When you go for visa stamping, if they have to look into this a little further, you could be delayed a few weeks. If the case is dismissed, that should be the end of the story. They should not need to, if you go for visa stamping and you have your certified copy of the court order, court disposition, that should be enough. The final disposition is given by the court, so you will get it as a certified copy of the final disposition from the court clerk. I want to make a very important point, and the fourth question asked by Ash brings up that point. Can we ask FBI to remove the fingerprints? It doesn't matter. Even if your records are expunged, you still have to tell the immigration authorities that you were arrested or convicted or whatever proceedings they were. Expungement does not mean you can walk away from confessing it under immigration law. Very, very, very important. Okay? I hope that covers all the questions. *5 if you have a follow-up question on this. No new questions, only follow-ups on criminal law issues. Press *5 on your telephone. So I have one from area code 952. 952, where are you calling from?
Minnesota.
All right, sir. Go ahead. What is your question?
Based on what you said, the fingerprint kind of a thing. Suppose we impunch that fingerprint, and what I've learned here is that. So I have only two questions. What I've learned online here is that if you file an impungement, that itself is a new document which goes into public. ICE officers might be sitting there looking for these applications, right? So, is it in your opinion? First question: is it in your opinion even filing an impeachment is the right thing to do, kind of a thing, or kind of thing? And second question, which I have here, is that can we take when we go for visa stamping or for new visa kind of a thing? Can we take a private immigration authority for explaining the scenario in a more adherent, clarity way, kind of a thing? I'm so sorry, sir. There is a third question. If you don't know, does Canada um, uh, work permit gets into problem because of dismissed case?
Okay. So
That's all, sir.
let me begin with the easy question. I do not know the Canadian laws, so I will not comment on that. But I will tell you this, that generally under common law, remember Canada is a common law jurisdiction. Unless there is a conviction, there should not be a problem, but I do not know Canadian law. First question, expungement. First of all, even if you get the records expunged, whenever you encounter the question in immigration law anywhere, have you ever been arrested, charged, detained, etc.? You have to say yes. You have to say yes. Just because the record has been expunged does not mean that you did not have a problem. So immigration law doesn't care that the record was expunged. Does it show up as a document by itself in public domain? I have no idea. But it is generally a good idea to get the record expunged. Why should you not? At the same time, do not forget to answer the question yes under immigration law. If you answer no, you could be permanently barred from entering the United States because that could be construed to be fraud. Okay, so your second question was, I'm sorry, I forgot. First and third I answered. Can you remind me what your second question was?
The second question is, when we go for visa stamping, can we request
Oh yes,
local
oh yes,
immigration?
oh yes, oh yes. Yeah, we do it all the time. Lawyers provide letters explaining why you should not have any trouble at all in getting the visa stamping, explaining the law, explaining the facts, and the consulates do consider them. Yeah, I think it can be done, no problem. What else?
What I really mean is that suppose your firm, as somebody can accompany to the interview window.
Give me 1 second to explain something to you. There is no right to counsel in visa interviews. Okay, you don't have a right, but if the consular officer allows, certainly somebody can go with you, and we do have our team in India as well. We can always ask one of our lawyers from India to go with you, but there's no guarantee that they'll be allowed to really talk much at the counter. Okay. Good luck.
Yeah.
Okay, going on to, let's see, I don't think I have any other I have no other frequently asked questions. Now let's go in order, other questions that were posted. Question number 4. H4 EAD to H1, H1B transfer extension approved, I-140. I had the hardest time understanding this question. I actually don't know what's going on. 3 months left. Oh no, this one was easy. There's another one down somewhere which is really odd. I have 3 months of time left on my 6 years. I-140 got approved with employer A. Currently working with them on H4 EAD. He didn't hold my H1B. That's not a problem. It has been more than 6 months since my I-140 was approved. I would like to change employers. Yeah, they will revoke the I-140. I have a valid H4 EAD for 1 year. Can I change employer B now and work for 1 year in H4 EAD, then convert H4 to H1 based upon the approved I-140? Absolutely. That's a very good way to go. And even once your I-140 is approved and has stayed approved for 180 days after January 17, 2017, you are then entitled to continue to use that H1 to get to that I-140 to get H1B extensions, even if the old employer revokes your I-140. So you're sitting pretty. You're looking good. I don't see any problem. Work for 1 year on H4 EAD, then convert to H1. Yes, so all questions have been answered. Star 5 if you have a follow-up question. Press star 5 if you have a follow-up question. Okay. I remind you, please don't ask me a new question. Just follow up. Area code 612. Where are you calling from?
Hi, sir. We are calling from Chicago.
Yes, ma'am.
Okay. So, just to confirm, so you're saying it's okay, I can change from H4 to H1 even down the line after 3 years with this approved I-140 from this employer, right?
That is correct.
Okay. So I can still use the I-140 even if I change to a different employer, and I can use this 140 for my H4 to H1 confirmation. Okay. All right.
All right.
I think I'm clear on what I have asked.
Good. Good luck.
Thank you. Thank you, sir.
You're welcome, ma'am. 221G, this is number 5. 221G white slip admin processing. My I-129 was selected in H-1B with previous employer in 2016. I received an RFE, then the RFE was approved. This is back in March 2017. On visa interview date, I received a white slip, 221G. Employer sent the requested documents. After some days, when I checked USCIS website, status changed to admin processing. October 2017, the status changed to revoked. Is my petition still valid? No, sir. A revoked petition is not valid. Okay? But let me try to think about this. Can you be exempted from the quota? There might be some argument there. So I'm actually right now doing a case which has an interesting problem. And we are keeping our fingers crossed that we don't have to go to court over it. What happened was, this young lady got her H-1B approved. The employer had several projects and they didn't realize they had assigned her to one of their projects which city she was not approved to work. And actually the salary was much lower than the city she was approved for. So the point is, they're not trying to cut any corners, and they did have projects in both cities. Very oddly, there was a site visit and government moved to revoke. We fought that and said this was inadvertent, but the government revoked the case. I filed an H-1B again. I said the revocation does not affect the fact that she's out of the quota now. She doesn't have to go back to the quota. Because the revocation was not for any defect in the H-1B. It was for a violation of the H-1B. So therefore, she was approved and she stayed approved until she was revoked. So I would make a distinction. I don't know how well it's going to work, but I think it's a clever argument that there are two kinds of revocations. One revocation that goes to the date of approval. For example, if you committed fraud or if you gave incorrect information. But there's another one where after you've been approved, you have violated the H-1B. In the second kind, you're not subject to the quota. In the first one, you are. So you're going to have to talk to your employer about this. I don't know why your case was revoked. Is your petition still valid? Definitely not. But are you outside the quota? That depends upon the type of revocation. How long the 2016 approved case is valid for visa processing? Well, technically, as long as the job is available and it's still valid. But the approved case has been already revoked, so this is a useless question. I don't mean to insult you. What I mean is that this question doesn't belong here once your case has been revoked. The third question is what I just answered. Can my current employer use that petition and be accepted from the lottery process? Depends upon the revocation. I just gave you that example. Check with your, you can play this for your lawyers and just maybe they want to explore this argument and kind of use that. Other than that, I can't see anything else I have to say on this issue. Star 5, if you have a follow-up question. Star 5. Oh yeah, by the way, I forgot to tell you. The second case that I filed, it is now under RFE, which means the government has not challenged my argument. The RFE is about some other things like degree, this and that, small minor things. But they haven't challenged the big thing, which is she subject to the quota when the case was revoked? Apparently, they agree with me that this revocation does not take her out from the quota exception. Okay? Let's go to question number 6. EB2 to EB3 downgrade I-140 processing time using AC21 supplement J. So 2012 case was approved through company A. Company A was bought by company B. Company B filed successor in interest as well as downgrade to EB3 I-140 with 485 October 29th, 2020. Laid off 90 days after both. H1 transferred, joined the new company, H1 applied. I-140 is pending more than 180 days. Well, here is the problem. Unless the I-140 is approved, that 485, that downgrade could be zero. That could be of zero help to you. If they won't respond to an RFE, if it gets approved, you are good. It doesn't matter that you left before, after 90 days of filing. That's fine. So what are your chances of I-140 approval? Normally they should be good because you said these are huge companies and if the work has been done right. I'm not worried about you leaving before 180 days. That's not required by the law. If the I-140 is approved, you can definitely use I-485J where we use it all the time. The key here is I-140 approval. It does not matter that you left before 180 days. That's perfectly okay. Star 5, if you have a follow-up question. Star 5. Okay. I can see you are calling from Los Angeles, right? LA?
Yeah, I live in Bay Area, Rajiv.
Yeah.
Thank you so much for doing this.
Absolutely. Go ahead.
Thank you for answering. I think I'm clear.
Mm-hmm.
So just one follow-up. I think you certainly answered, but just wanted to make sure I understood correctly.
Mm-hmm.
I understand that the 140 approval, I know I'm hanging on a thin air here, but just hoping against hope. If 140 is approved, I understand the scenario. But the chances of 140 approval are, if USCIS sees that while the time of 140 being adjudicated, we see a H1 transfer, did I understand correctly that should not impact? And
it should not.
Approve or
it
deny
should
140 on the basis of itself?
It should not.
Okay,
it should not. The last time I looked at this issue, I noticed that the USCIS has been going with a construction that says as long as the I-140 was approvable when filed, we don't care if you left.
Okay.
So approvable when filed mantra. Okay.
Got it. Thank you so much.
You're welcome. Okay. So question number 7, H4EAD and Limited Liability Company, LLC. Can an H4EAD holder start single entity or be partner to open an LLC? Oh, I'm sorry. I'm going to go back. There was another question from area code 614 that I didn't see. Area code 614, where are you calling from?
Yes, Rajesh, I'm calling from Ohio. So my question was a follow-up to the previous, as you rightly prompted. Just to know, in this similar situation, because if the person has left the company before 180 days of 485 is pending, is it still filed to use supplement J?
I would want to see the result of the I-140 approval. Is your case that the I-140 is already approved?
Yeah, like I was just trying to understand generally since this came up, this kind of situation, that if I-140, let's say, got approved and because the person has left the company before 180 days of approval,
right?
180 days of 485 pending, is it still possible to file supplement J with a new employer?
I would not want to until the I-140 is approved, because you don't really have the AC-21 locked in yet. AC-21 gets locked in when the I-140 is approved, not before that.
Correct. And also the 485 has to be 180 days pending.
That's the second part, which is not in question right now. So I don't like to expound upon unnecessary facts. The bottom line is, for this particular discussion, until the I-140 is approved, we've got nothing.
Okay, I see.
Once the I-140 is approved, then the next question is, has the 485 been pending 180 days? Yes? Great. We are all set.
Okay, I see your point.
Okay?
Mm-hmm.
Good luck, sir.
Yeah.
Back to the LLC limited liability, question number 7. So can you start a company by yourself when you have H4EAD? Absolutely. Because an H4EAD actually has more rights than an H1. You can start it by yourself or start it with another person. So what if the EAD has expired? What happens then? You should stop working until this next EAD comes through. So you're not allowed to work. But if you just hold equity, and let me give you an example. Let's say you were flipping houses in that business. So your partner and you used to go out, see properties, and scan newspapers for auctions, etc. You can't do any of that. But you can still maintain your partnership as long as you do no work. Okay? Star 5 if you have a follow-up question. Yeah, your partner can continue operating the LLC as long as you don't work actively in it. Doesn't look like we have a follow-up question. Okay, now this one is the one that kind of, there's one question, I don't know if this is the one. My current employer, this is question number 8 posted by Deepa from our team. My current employer's prevailing wage determination for green card has been filed. PERM filed by October-December. It won't be certified in the narrow time for I-485 filing when my old retained priority date is likely to become current. Old I-140 sponsoring employer terminated me very inhumanely. No notice for false reason. I-140 by this old employer stayed approved for 2 years and they didn't bother to withdraw it. Can I use it to file 485? Absolutely not. Because 485 filing requires a current offer from the employer who processed your I-140. You should not use it to file 485. Government is likely to consider that to be fraud. No, sir. The rest of the question doesn't need to be answered because, in my opinion, filing a 485 through an old employer's I-140, that employer not supporting it, would not be a good idea. Star 5 if you have a follow-up question. Star 5. Okay. Question number 9. Changing jobs while I-140 is pending. Project with the end client is ending July 21. Filed for 485. Received EAD and EB3 downgrade. I-140 is still pending for more than 180 days. I am pursuing full-time jobs, wondering if I should stick to H-1B status. I think you should stick to H-1B status at least until the I-140 is approved. I actually like to maintain H-1B status all the way to the end, until the green card is actually approved. Okay, but if you're going to lose a job because they're not going to file an H-1B, by all means use that EAD since you are so close to the end according to you. Star 5 if you have a follow-up question. Star 5. Okay. Question number 10. You were born in UAE So great. Yeah, you are under other than India categories. You can get to do green card directly, sure. But parents cannot, yeah, parents, I don't see any reliable way of having your parents come and stay with you. I don't. Okay. There are some provisions for non-immigrant visa holders to get their parents, for example, or non-qualifying derivative beneficiaries to come and stay on tourist status and try to extend that. But we've done that for many people. We are continuing to do that. It's not reliable. And once you get a green card, it may not be usable. Technically, that is to be used by the family members of non-immigrant visa holders who do not qualify for direct derivative status, such as child or spouse. So I don't think that's a reliable method. You might want to think about other options, whether parents can qualify for an H-1B if they want to work, or they have some other independent way of getting in. But I don't think this is a reliable method. You can't depend upon it, that they'll come in as your non-qualifying derivatives on a tourist visa. *5 if you have a follow-up question. *5. Okay. So this is the one that was very confusing from Venkat. Venkat, what the heck is this? Venkat, if you're on the call, question number 11, press *5. Okay, excellent. You are from New Jersey, Venkat?
Hi, Rajesh, sir.
Oh, don't call me sir. Just call me Rajiv. You are from New Jersey. Okay. Let's go over your questions. I kind of got lost in the narrative. Let me make sure I understand this. You are on H-1B. I-140 is approved. Wife is on H-4. She applied for H-1B in 2021. It was approved with change of status. Now this is this year. So that means she will be in H-1B effective October 1st, 2021, correct?
Yes, but her H-1B is not approved, but it's not a continuous approval because it's a change of status. So she has to go back to home country, get it stamped, and then come back.
Oh, so she did not receive a change of status. So she did not receive a change of status.
She did not receive a change of status. That's correct.
Because that's where I got confused. Your line says applied for H-1B, approved with change of status.
Oh, no.
Okay, so
yeah, that I-797B. Yeah, I'm sorry for that.
Okay. So that's why I was like, Venkat is trying to trick me. He's trying to think that let's see if this old guy knows what he's doing. Okay, very good. So her H-1B is approved with change of status. You again say it is with change of status?
No. Her H-1B is approved, but it's not with the.
So without change of status.
I-797B she received.
Okay.
Without change of status. That's
okay.
What I mean to say.
Okay.
So sorry, yeah.
So no worries. H4 extension is approved on 9th Feb. H4EAD is in progress. She went to India for a change of status. Attended her H1B, 221G. H4EAD is approved. Yeah, I think if she comes back with an H4, if she comes back on an H4 visa, she can use her EAD, no problem.
Okay. But I have a question here. So now she went for the visa interview for change of status on H-1B.
Mm-hmm.
They issued the 221G.
Mm-hmm.
Unfortunately, they asked for the passports drop, and
Mm-hmm.
then she dropped her passports.
Mm-hmm.
And then again, she went to collect her passports back. Again, they issued another 221G.
Mm-hmm.
Now my follow-up question on this is, now since her H4 EAD is approved, she wants to come back on H4. Now her current H-1B visa application is pending with embassy. Can she book another H-4 visa appointment with US embassy? Or she needs to withdraw her pending visa application with embassy before she is applying for H-4?
You have to contact the consulate. I think she'll have to withdraw. Okay.
Okay.
What else?
Yeah, that's my that's my question actually, Raju. Thank you so much.
Good luck, Venkat. Good luck.
Thanks.
Okay, yeah, Venkat had me all confused. I was like, this doesn't make any sense. So good. Now this does make sense. So I-485 supplement J denial. If you get denied because the jobs are not same or similar, sue the hell out of these guys. But of course, I don't think it's a denial of a 485. You can get another job and file supplement J again. I think so. I have to look at the language because it's never happened to me in 30 years. We've never had a supplement J denial. So it's very odd that government will take that position. Okay. The last question for the day. Oh, I'm sorry. Star 5 if you have a follow-up question. Vicky, if you have a follow-up question, star 5. Okay. Last question, and then we'll start with new questions. 485 supplement J processing time due to job change. I've submitted my 485J due to job change. Will this delay the processing of 485? Yeah, it can. How long will it take to get approval? Who knows? Is there any rule that after getting the green card I have to stay with the company for a certain period of time? We have lots of frequently asked questions on this. I'm not going to repeat that. Please go to our frequently asked questions on immigration.com. You will be able to see this issue discussed at least 10 or 15 times. And not much has changed. It's the same law. Star 5 if you have a follow-up question. Star 5. Okay, anyone has any question, press star 5. Anyone has any question, press star 5, and we'll start taking them one by one. So far, I have only 3 questions. 4. Okay, 4. 4 is easy. All right. Everybody's sure? Nobody else has a question? Okay. Let's get started with the phone number, area code 973. 973, where are you calling from?
Hi, Raju, how are you? So I live in New Jersey.
Okay.
I have a situation. I would need some guidance.
Tell me.
So I work for a company in New Jersey.
Okay.
No remote is allowed.
Okay.
My wife is in H4. I'm on H1. My wife is on H4 and she has a EAD and she doesn't work currently.
Okay.
I have a kid, 3-year-old, who's born here.
Okay.
Right? Now, the situation is they are really struggling with the weather here during the winter time. In fact, from September only they really struggle.
Okay.
I don't want to leave my job and go to a different state.
Okay.
So I want to continue in New Jersey.
Okay.
I'm planning to sell my house and I'm going to rent a small place just for me to stay here and continue to work with my employer. Right? Okay. Now, my wife, I'm planning to send to some warmer state, right? My wife and kid, and we are planning to legally lease a place on my name and my wife's name. Right. And she will probably look for a job in that state, right? Now, this kind of setup, right? Does it create any confusions?
No,
to immigration?
I don't see any confusion. It's quite clear. Nothing wrong with this. Okay.
Okay, but Raji, the thing is, which address I have to give to my employer? So I'm going to, because
your address should be, sir. Your address should be where you live, not where your family lives.
Okay, but they will be processing my wife's H4 extension as well, right? In that case, when the H4 extension is due, for example, right?
Then you give her address. Give her address and your address. They can be separate. No problem.
Okay, so I'll just take a few more seconds why I asked this question. So I was browsing through online in some forums, right? I saw a question posted by someone saying that his wife's H4 extension was denied, saying that the H4, the principle, right? The reason for H4 is to stay with the H1.
Okay.
So
that is complete and utter nonsense. Okay. Okay. Now I'll ask you a question. Have you ever posted a question in our forums before?
Not exact, no.
Okay. So I was looking at somebody's comment on our YouTube forums or YouTube community, and actually I usually disable the comments. It's difficult to deal with all of that. Somebody posted a comment, I'm getting a lot of spam from our forums, and I know for a fact that there is no spam. We actually have zero spam. So anybody can post anything they want. And when I track this guy down, he has zero videos and just like a fake account created for the purpose of sprouting nonsense. Okay. So just because somebody posted on the forum doesn't mean it's true. There are plenty of people who post nonsense. All right.
Okay.
Good luck.
Sure, Rajesh. So one last question, if you don't mind. So have you seen like any of your clients with this setup? The H1 primary live in one state and the H4.
You know why don't you do this? Why don't you pick up the phone and call the USCIS? Okay.
Oh, no, thank you. Just wanted to hear from you.
No, it's a good idea to call the USCIS. Why not? And if they tell you anything different than what I told you, call me back. Okay.
Okay.
Good luck.
Sure,
Good luck, sir. You're welcome. Okay, let's go on to the next one. Let's see. This one is from also area code 732, New Jersey. Go ahead, please. New Jersey. Oh, sorry. New Jersey, area code 732. Go ahead, please. New Jersey.
Hi, Rajuji. Thank you for all your support on the answering all the questions.
My pleasure.
Hello, can you hear us?
I can hear you. Yes, sir.
Hello.
Yeah, I can hear you.
So the question is, is it legally to work with an employer under H1B, parallelly working with a different company under EAD? So I have
No. Hang on. If you start using EAD, H1B is gone for now. So you can use EAD to work with two employers, no problem. Okay. And I'm assuming you're talking about 485 EAD, right?
Correct. That is correct. Yes.
You can, no problem. You can.
And my date is current, but still waiting. My date is current, and I'm still waiting for my green card, but I don't think it will come pretty soon.
Yeah.
But I got an opportunity to work with the two clients. I'm just thinking about whether I could work with H1B
Absolutely.
with my current employer and work with them.
No.
Work with
You can't have a mix and match. You can't have it's a bad example, but you can't have Windows and Macintosh running on the same computer at the same time without virtualization or containerization. It's kind of the same thing. It's totally separate processes. One takes over the other. Either you have the H1B and don't use the EAD. Once you use the EAD, your H1B goes to sleep. Okay?
Okay, but will there be any issues on if I continue using H1? Because the reason is my H1B still until
you cannot. You cannot.
Time.
You cannot. It cannot be done. It is legally not allowed. They will consider you to be on EAD.
Okay. But I can continue with the EAD without any issues, right? Until I get.
Well, I don't know what the issues can be, but it is legally allowed. Without issues, I mean, even the good Lord can not tell you right now. It all depends upon how. See, as long as you maintain the intention to continue working with the sponsoring employer, what you do on the side is your business.
Okay. And one last question is on the EAD, whether I can able to open a C Corp or maybe S Corp from my own to work with the.
You can. I don't know about S Corp, C Corp for sure. S Corp, you need to check with the CPA. You can definitely open a C Corp or an LLC, and you can even do business on the EAD as long as you don't lose your intention to stay with the current employer.
No, I would like to be with the current employer and then parallelly.
Yeah, you can do that. You can. Yeah, no problem at all.
Okay.
Okay. Good luck. I gotta go, guys.
Yeah, thank you.
Mhm. Okay, let's do area code 614. Is that Minnesota? Where are you calling from? 614?
Yeah, I'm calling from Ohio, Rajiv ji.
Ohio.
I was not sure. Did you cover question number 8 actually that I had posted?
Let me check.
I
Give
was
me.
not sure since I had to take a work call in between, so just making sure.
Yeah, I've already covered it. Listen to the recording. Okay, gotta go.
Okay. Sure.
Yeah, just to give you the bottom line, unless you are working with that employer, you can't use that I-140. Okay?
Okay. Okay.
Good luck.
Thank you.
Area code 952, the last call. Where are you calling from, 952?
Amen.
Hello? Minnesota?
Hello.
Did you say you're calling from MN?
Yeah.
Okay. Tell me, how can I help you?
I think this would be a very generic question. I don't know.
No worries.
The embassies are closed in India, right? So if you are if your spouse and they are or somebody goes now back to India and how fast they can get the visa stamped again and come back. That was the only question I had. And
Okay,
if you are aware of it.
So there are two issues right now. One is getting the visa appointment, and the second is being exempt from travel ban. These are two different issues. So first of all, getting visa appointment depends upon the local consulate. You can email them, ask them, try to see what is the earliest appointment available. Separate issue. The other issue is, once you even get the EAD, can you travel? And if you are exempt, if you have a national interest exception, you should combine the two, the visa application as well as the NIE, and get them both together. So right now, that question is unanswerable in the format you asked. Every case is different, but I've given you the solution. Contact the consulate to find out if they are indeed working, and if they are working, how soon can you get an appointment? And if you do, people are getting visas, it's just that it's very difficult and takes a long time. You also need to make sure that she's exempt from the travel ban. Got it?
Can travel exempt be given example that your kid is having school year and
hang on. There is no exemption from getting a visa. Okay, but as to the national interest exemption, I have an article on that in the Economic Times. If you look at my author page on the Economic Times, and I also have it in my blog. So if you go to immigration.com and go into my blogs, who is exempt based upon business reasons is all listed there. Okay. Now, if she has, do you have any US citizen children?
Yeah.
Okay. So if your children are minor, your wife is automatically NIE covered. She doesn't have to apply for an NIE. Okay. But she still needs a visa to come back. So your NIE problem is solved because she's not covered by the current travel ban. However, she still has to get a visa, and either she gets it from a third country, whichever country is taking applications like Costa Rica or Mexico, or she has to get it from India, and whatever time it takes, it takes. Okay?
You mean to say you can apply from India and send the application to Costa Rica?
No.
Sorry,
No. You have to be there personally. You can't just mail your application to Costa Rica. Okay? You've got to go there personally.
There is no virtual kind of a thing.
That would be too logical. Government doesn't do logical. Okay?
Okay.
Good luck, sir. Okay. We still have two questions. Guys, where did you come from? Okay, let's see. Area code 312. Go ahead, please.
Hello, Ravi sir. Thank you so much for your help.
Of
I
course.
just had a quick question on the H4 EAD renewal.
Mhm.
If the primary H1B's receipt number is on with SRC,
Mhm.
the application goes to which address for the H4 EAD renewal?
I am unclear about your question. Are you asking me where you get the receipts for the H4?
No, where to send the H4 EAD
Oh, I have
renewal
I have
application,
no
which is on
idea.
the web.
I have no idea. This is
Okay.
something our team takes care of. This is tertiary and quaternary. Follow the instructions on the USCIS website where to send the H1B or H4 EAD.
Okay.
I have no idea. Sorry. Good luck.
Okay, thank you.
You're welcome. Okay. And the last question, area code 512. Let's go to 512. 512, where are you calling from?
I'm calling from Austin. Thanks for taking my question.
Yes, ma'am. Go ahead.
Cool. Yeah, this is a fairly quick question. I have an approved 140 with a 2015 priority date.
Good.
Right now I'm applying for EV2 NIW as a backup.
Mm-hmm.
So can I use my 2015 priority date for NIW?
Absolutely.
All right, that's all I wanted to know. Thank you.
Yes. Just to clarify this for everyone, the way the transfer of priority dates works, two things you need to remember. One, the USCIS is automatically obliged to give you the earliest priority date to which you are entitled. You should not have to do anything about it. Okay? Automatically entitled, and it's the USCIS's job to give you the earliest priority date. Number two, priority dates can be transferred across EB1, EB2, EB3. So if you have an EB3 priority date, it can be taken to an EB1 case. If you have an EB1 priority date, it can be taken to an EB2 case. They are all internally transferable. So you're all set, no problem. You'll be fine. Good luck.
Yeah, thank you.
Bye-bye. Folks, it's always a delight to talk to you all. I'll see you again in 2 weeks. Be well, everyone. Bye-bye.